Hi, I'm Emily, and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, my father passed away with a will and a trust. I am named executor and trustee. What do I do next? Do I file everything with the court, and how do I do this?
Good morning, Emily, and thank you for this question. In Connecticut, the executor or fiduciary appointed in a will is expected to initially file the will, the certificate of death, and a petition for probate with the local probate court where the decedent last resided at the time of their passing. There is no hard deadline per se, but the probate courts typically like to see this initial filing within 30 days of the decedent's death. Depending on whether the trust is a complete pour-over from the will, meaning all of the will assets are put into the trust, the probate court may not wish to oversee or get involved with control or approval of trust administration unless there is a challenge or objection to trust administration, or the terms of the trust dictate periodic reporting to the probate court. You will then be issued a fiduciary certificate appointing you as executor pursuant to the terms of the will after you file your petition. And this carries obligations and duties imposed on you under the law. An executor and trustee or administrator or fiduciary, depending on the situation, is entrusted to carry out the administration of the decedent's estate by marshaling, valuating, and distributing assets, as well as satisfying any debts if the estate is solvent enough to pay them. This means collecting financial statements and finding out where everything is held. Most wills and trusts have clauses that empower the executor to hire lawyers and accountants to help them perform estate administration work. There will be deadlines set down by the probate court for each step, including filing of inventories of assets, lists of creditor claims, and an eventual estate tax return, if any, as well as payment of probate fees. A final financial report depicting all money coming in and going out of the estate by whatever transactions were necessary or ordered will have to be filed to demonstrate a well-administered balance of final costs and distributions before the probate court approves that the estate can be closed. As I tell clients, estate work is sometimes notoriously slow. On average, the process can take up to a year, sometimes longer. If you are the executor of a will and you must begin the probate administration process and you are not sure where to start, please call me today at Maya Murphy PC at 203-221-3100.
Attorney Fink is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fink at efink@mayalaw.com, and please visit mayalaw.com for more information.